Welcome everyone. Thank you for taking time out and joining us for today's webinar. Capture the latest Greater Bay Area opportunities with Hong Kong as your arbitration hub, as co-organized by the Hong Kong Trade Development Council and the Hong Kong International Arbitration Center. I'm Louis Chen and I will be your moderator for today's event. Our aim here today is to discuss a number of the unique opportunities in the Greater Bay Area or the GBA, while also considering how best to leverage on Hong Kong's advantages as an arbitration hub within the region. Now, for those who are not yet familiar with the GBA, I would like to give you a quick introduction while leaving our distinguished speakers to go into greater detail. The GBA development is one of the major policy initiatives of the Central People's Government with the aim of creating a Pearl River Delta powerhouse that links Hong Kong and Macau with 9 Guangdong cities. The transformation of the region, which encompasses a massive market of 72 million potential customers and a combined GDP of 1.7 trillion US dollars over an area of approximately 5,600 square kilometers, is part of China's global vision, which seeks to establish a far more interlinked world with the wider Belt and Road Initiative. Compared with other city clusters across the group, the GBA currently has the largest population, land area, and number of top universities. Its GDP is higher than San Francisco Bay Area, but smaller than New York metropolitan area and Greater Tokyo Bay. Though through increased connectivity and with the advantage of a larger population, it's predicted that by 2030, the GBA will exceed the other city clusters in GDP, providing massive opportunities compared with its counterparts. Now, while it is not difficult to see why the GBA has immense potential, the region's unique combination of 1 country, 2 systems, and 3 jurisdictions can be viewed as something of a challenge for the international business community. Thankfully, we have here today 3 experts on hand who will help us navigate through the many challenges and the many opportunities. Maria Tan Patterson, Freeman Yo, and Kieran Sangria. Today, they have kindly agreed to share with us their insight of how international businesses can benefit from using Hong Kong, the only common law jurisdiction in China and a well-recognized arbitration hub, to fully capitalize on the promise of the GBA. Now, while I'm sure they will be familiar to many of you, so distinguished a panel certainly merits introducing. Among her many achievements, Maria Tan Patterson is a partner with Decade LLP. She is a leading international projects and commercial lawyer with extensive and diverse experience in advising corporates and governments worldwide and has practiced in the US, Europe, and throughout the Asian Pacific region. For his part, Freeman Yo is the co-leader of Silly Austin's Global Arbitration, Trade, and Advocacy practice, as well as a core member of its litigation and regulatory group. With many years' experience in handling complex business disputes in Asia Pacific, he frequently represents clients under different terms of institutional and ad hoc arbitration rules. Finally, Kieran Sangria serves as a special counsel for the Hong Kong International Arbitration Center, leading its domain name dispute resolution team, while also overseeing the center's business development activities. Prior to joining the center, she worked for the Secretariat of the ICC International Court of Arbitration in Paris. And now, just before we begin, a few rules of engagement. Today's webinar will take the form of individual presentations, followed by a 3-way panel discussion. If you have any questions for our speakers, please feel free to submit them via the question box of your Zoom control panel. I will then ask them on your behalf during the Q&A section at the end of the webinar. Now, Please allow me begin proceeding by welcoming Maria Tan Patterson. Drawing on her own experience, she is going to outline just how ASEAN companies can best seize the opportunities of the GBA while minimizing any risks. Maria, the floor is yours.
Thank you so much for that kind and wholly undeserved introduction. Thank you for the opportunity to speak today. Again, I'm Maria Peterson, a partner at Deckert, and I'm also a member of the HKIAC Council. And my role today is to discuss the transactional perspective and ways, hopefully, to minimize disputes, although it is not my goal to put my arbitration colleagues out of work. So we talk about opportunities in the GBA. My perspective will be that of how GBA participants and ASEAN participants can work together in joint projects, whether they're inbound or outbound. And there are 2 points I want to make at the beginning. Well, first is that the BRI is a very wide-ranging initiative of which the GBA will be part. And therefore, where you sit in the project chain will impact your perspective and the risks and issues that you are concerned about. Participants can come in as sponsors, technical partners, operators, consultants, and licensors. And it's very important to keep in mind what that perspective is in reviewing the risks and lessons we're going to discuss today. The second thing I just wanted to note is the BRI has been around for a little bit now, and there are a couple of interesting trends I want to note in terms of growth areas. One of them, of course, is that energy and infrastructure will continue to play a key role in ASEAN's economic recovery. But interestingly, in 2020, renewable energy made up a majority of the BRI investments for the first time, according to certain sources. Other aspects for growth include logistics, which is not surprising given the recent pandemic events, and of course, digitalization. Next slide, please. And when we talk about digitalization, I think that is probably accelerated by the pandemic situation. And so therefore, we've seen a huge increase of investments across ASEAN in e-commerce, health tech, fintech, and AI. I say this by way of context as we go into actual considerations for those wishing to participate in cross-regional projects with ASEAN countries. So some certain upfront factors to consider in what I call the pre-deal phase are the objectives of the parties. What constitutes success? Second, what are some of the hurdles in achieving those objectives? Questions that parties should be considering at the very early stages is, what does success look like for them for this particular project or transaction? And if things go wrong, what are some exit strategies? Are you looking for a long-term business relationship, or is this a one-time opportunistic approach? Would a minority investment be appropriate, or a joint venture, or an outright takeover? Next slide, please. An important note I'm sure everyone here is aware of is that ASEAN is not a one-size-fits-all region, and there are distinct disparities across the many countries that form ASEAN in terms of regulatory, policy, and political framework. So a very important upfront approach is to look at the structuring considerations required by the local markets and how these can impact your ability to achieve your commercial objectives. This sounds a bit intuitive, but it is often in the rush to reach a deal. Sometimes there's not enough diligence on the local level as to exactly how the deal would look. Next slide, please. Next slide, please. So joint participation requires a successful management of the joint venture relationship. And it's important that the parties underline that they're aligned and understand each other's goals in the venture. When drafting and negotiating the participation agreements, risk mitigation is obviously a key concern. And we look at a few areas in particular. First, of course, it's governance. and whether there's a clear division of responsibility and a transparent mechanism among the parties, which hopefully will be allocated according to the party's strength. Financial issues such as cash flow, dividend distribution, basic governance controls, intellectual property rights, and of course, the ability to carry on their own businesses or to protect the venture from competitors. Transfer restrictions are another component to consider, and of course, dispute resolution. While certainly certain factors that we are discussing here are not specific to ASEAN, but they do tend to come up a lot in the ASEAN context. The prior slide talks about three of the gating issues. The first being foreign investment and participation restrictions. As you know, many ASEAN governments have regulated the extent and sectors for foreign participation, levels and limits to foreign participation, and permissible structures. If financing is going to be a consideration, it's important to understand the security landscape and be prepared to address the concerns of your potential financiers. In a number of BRI projects, land access rights are also an important consideration, and particularly important in the context of linear projects such as rail, road, energy, onshore wind, and solar. Permits and licenses and other hurdles are important to understand as well. And going back to the financing requirement, it's important to structure in anticipation of your potential financing needs, because it's quite difficult to backtrack and fix these issues later on. Next slide, please. So ASEAN jurisdictions tend to have local content requirements because projects are viewed as a way to stimulate local markets and also to achieve a certain amount of technology transfer. So it's important to be aware of and to work around these requirements. Customs and import regimes, in terms of the level of equipment, of course, being brought in. Environmental regulations, an increasingly important aspect, especially in the financing front. And interface risks, understanding that your project is unlikely to exist in a vacuum, and that number of related projects may impact the success or risk related to your own project. So keeping a broader perspective is quite important. And the anti-bribery and corruption note on this slide really doesn't need much discussion. It's bread and butter. It's part of the infrastructure of everything that we do in this region, and definitely part of the financing considerations. Next slide, please. So as transactional lawyers, our contractual drafting is all about risk mitigation, the recognition that these projects have a life cycle and things will change, and there will be many unforeseen events. So our goal is to draft documentation that will withstand the tests of these often unforeseen developments. And a carefully drafted set of documentation is really the most important tool of participants in these cross-regional projects. Next slide, please. One thing I do want to say is don't be afraid of confronting the hard issues early on. It will save a lot of heartache. There's a tendency in the early stages of a deal to avoid or to postpone addressing difficult issues in order to get the deal done. And there are certain cultures where we're aware that that type of discussion can be quite uncomfortable. From the practitioner's perspective, and from those of us who've seen the whole life cycle of these transactions, unless it's absolutely necessary, we really urge participants to identify and confront the hard issues early on and address them in the documentation. Another aspect in terms of risk mitigation is to be aware of liability gaps across the chain of project participants. Because in determining risk mitigation, there are multiple participants in these different projects, and so the flow down of liability should be carefully considered. When we're now looking at a couple of key clauses that we like to look at in various agreements. But I'll say at the outset that there are many, many different types of contractual arrangements that can be involved in BRI ASEAN projects. And therefore, not all of these clauses may be relevant. So I've taken this as an example from sample concession agreements that tend to be in place for large-scale projects. One of the clauses, of course, is the change in law clause. Given the life cycle of many of these transactions, there can be unforeseen changes in law, which can impact heavily the risk profile or the economics of a project. So one thing to discuss at the beginning is who bears the risk. In a government-granted concession, private sector parties will ask that this risk be borne by the government. But it is, again, something to consider. Next clause. Another important clause is the liquidated damages provision for performance shortfalls or delays. This again allows parties in a contractual setting to agree to a formula on exact payments to be made for specific events, and also provides lenders and other contractual participants with certainty in terms of project costs and risks. But one thing to keep in mind, of course, in liquidated damages is to flow down your liability down to the contractors who are eventually responsible for some of the day-to-day. Next slide, please. We come to force majeure, and I would hazard to say that during the pandemic, there's no contractual provision that has probably been reviewed as often as the force majeure provision. This has really been tested by COVID, and I think highlights the importance of looking at what would otherwise be viewed as a boilerplate clause. Just be sure that the parties have agreement on what specific events constitute force majeure, the materiality of the event and its impact, how difficult or how adverse must it be to constitute a force majeure event, and of course, developing a process, outlining clearly a process for notifying and resolving force majeure claims, and what happens if a force majeure event is prolonged. Again, COVID has really been a test of how these clauses have been drafted and are interpreted. Next slide, please. In the life of a project, of course, things will change, and the scope and deliverables of the parties may also change, which is why we strongly recommend clearly drafted variation procedures. And in terms of the clarity, we're looking at what constitutes a variation and who initiated it. Is it a government-driven variation, a sponsor-requested variation, or a contractor-driven variation, which will then flow into the process and liabilities for cost coverage. Next slide, please. I almost hesitated to put this in here because as lawyers, we hate negotiating these clauses. But it's quite important to note that indemnities can be another useful tool for the parties to agree how to allocate risk and perhaps avoid the necessity for a dispute. In the indemnity provision, the parties can contractually agree on a mechanism where parties can pay or who pays what for certain events. And therefore, certain disagreements can be resolved without having to go to dispute. Next slide, please. No one likes to focus on this, but termination scenarios also need to be clearly and well addressed in agreements. In this case, there are two aspects of the termination provision that should be addressed clearly. One is the events of termination, what actually gives right to a party to terminate the agreement. And second, the consequences of termination, both financial and practical. Often we see one or the other addressed clearly, but not both. And I want to emphasize that both are equally important. In the context of government agreements, where you have expropriation or nationalization risk, termination payments are usually agreed, which are based on a formula to help each party recover its respective costs. Next slide, please. And my fellow speakers will certainly touch on this in much more detail, but I'd like to note emphasize the importance of your dispute resolution provision, that it be well drafted and comprehensive. When we talk about dispute resolution, we really talk about how to save the parties time and money, which is one of the reasons we also tend to recommend a tiered approach, because there are a number of disputes that could be resolved in a commercially friendly way that does not require the parties to engage in long and expensive procedures. Arbitration is the topic here, of course, because parties will tend to require arbitration to avoid another party's home court advantage. In the context of arbitration, we do need to look closely at enforcement risks and enforcement likelihood. And I think now it's a timely opportunity to switch over to my fellow panelist, Riven, who will undoubtedly be much more eloquent about the dispute discussion. Thank you all for your time.
Thank you, Maria. Thank you very much for your enlightenment. Next up, can we welcome Riven Yo? Today, he is going to share with us the real-life experiences of a number of ASEAN companies who have already successfully leveraged on Hong Kong's arbitration platform to take full advantage of the emerging GBA opportunities. Riven, can't wait to hear your GBA story.
Thank you very much, Louis. Just picking up on where Maria has left off, and what I'd like to do over the next sort of few minutes is to look at how, from an ASEAN practitioner's perspective, particularly as a litigation lawyer, as a disputes lawyer, why I think Hong Kong arbitration is a viable choice for parties from the ASEAN region, particularly as it relates to disputes involving GBA and the Chinese parties. And I think it will be helpful to consider this from 5 different aspects of the arbitration process. And we will take a quick look and survey on the availability of arbitrators, the choice of counsel, availability of interim relief, and I'll explain this in a bit more detail, enforcement of awards, as well as the Hong Kong court's support for arbitration. Now, the first question that I get asked by a lot of clients is, will I get a fair hearing or a result if I go to arbitration in Hong Kong? Well, my response is that ultimately this very much depends on who you get as your decision makers, the arbitrators, in other words. Frequently, especially in larger disputes, it is quite common for an arbitral tribunal to comprise of 3 arbitrators, with each side appointing their own arbitrator and the institution appointing the 3rd and presiding arbitrator. Alternatively, there are some disputes which, by parties' choice and design, are to be heard before a sole arbitrator, and I'll also come to that. But insofar as the parties have a choice of who they choose as arbitrator, the first thing to note is that there is no restriction as to who parties in a Hong Kong arbitration may select as their arbitrator. As a starting point, HKIAC, being Hong Kong's flagship arbitration institution, has a vetted panel of experienced and qualified arbitrators from which parties can choose their arbitrators, although they are by no means limited to these names. And if you look at the panel of arbitrators, they comprise over 500 names, and they are individuals from all sorts of, all nationalities across the world. But interestingly, they include 50 ASEAN nationals, including some of the most preeminent names in arbitration. And that's significant because it represents almost 10% of the total numbers. And this is a clear recognition of the importance of the ASEAN market for Hong Kong. The availability of these individuals to serve as arbitrator is important because ASEAN parties will likely want to appoint an arbitrator who has an understanding or familiarity with their own business mindset, their legal culture, their working language, among other factors. Now, when each party selects its own national as their arbitrator, how is the third arbitrator selected? For example, with a dispute against a Chinese party, and that party chooses a Chinese national, is there a likelihood that we might end up with another Chinese national as a presiding arbitrator, a sort of 2 against 1 scenario? The quick answer to that is no, because the HKIC rules are very clear and imposes a neutrality agreement requirement insofar as the nationality of the presiding arbitrator is concerned, so that the presiding arbitrator cannot be of the same nationality as any of the parties. The same situation applies where the dispute is to be decided before a sole arbitrator, and the HKIC adopts the same nationality-neutral approach in making the appointment. So all in all, in the way that the tribunal is set up, I certainly think that there are sufficient safeguards to ensure that any apparent risk of bias is minimized. Now, in the same way that there is no restriction as to who you can appoint as arbitrator, there are also no restrictions as who may represent parties in a Hong Kong arbitration. Now, the fact is, disputes involving PRC elements frequently involve the use of Chinese language. And indeed, the choice of Chinese as the language, or one of the languages of arbitration, is on the rise. So I think it is almost a given that you need counsel who are well-versed in Chinese and who can be your effective advocate for your case. And to that end, I think Hong Kong is unrivaled in terms of Chinese language support. And this extends beyond legal counsel who are effectively bilingual in English and Chinese, and includes support services needed for the effective running of arbitrations, including legal and accounting experts, as well as interpreters, all of whom are readily available in Hong Kong. But on the flip side, Hong Kong also has a sizable ASEAN diaspora, many of whom work in the legal industry, including within the arbitration community. And they can effectively provide advice on both PRC as well as ASEAN elements in a dispute. The ASEAN community is also well represented on the council and various working committees of the HKIC. And so this ensures that the needs and the views of ASEAN users are regularly reflected. Another unique advantage, as I see it, that Hong Kong arbitration has over other arbitration venues when it comes to China-related disputes is the availability of interim relief from PRC courts in support of Hong Kong arbitrations. Now, ultimately, a party wants to ensure that a successful award is not just a paper tiger, as we term it in Chinese, or 纸老虎, but that there are effective means with which to enforce that outcome. Interim relief goes a long way towards ensuring successful enforcement. These are essentially preservation measures to ensure that the assets as well as evidence are protected from dissipation or destruction, which can happen, for example, when one is dealing with unscrupulous opponents. There are, of course, a number of options to seek interim relief in a Hong Kong arbitration, including through the courts, the Hong Kong courts, or emergency arbitrator procedures before the tribunal is constituted. But in these circumstances, time is of the essence because once the assets are dissipated or the evidence is destroyed, this can cause irreparable damage to a party's interests. A case on point, we had represented a Singapore investor in a long-running dispute against a Chinese party in a joint venture setting. The venture turned south, and the client then sought to exercise its option to buy out the joint venture party. Unsurprisingly, the parties were far apart in valuation, and as it turned out, the PRC side took steps to stop the investor from their informational access, including that its staff were stopped from or locked out of the office. So in that case, there was a real apprehension of misappropriation of corporate documents and corporate seal, which was supposed to be in the parties' joint custody. The foreign investor then applied for interim injunction before the HKIC emergency arbitrator to prevent the unauthorized use of the seal. And this can provide a powerful constraint on the respondent. But it may have very little deterrent effect on a recalcitrant party, particularly if it refuses to participate in the arbitration. Because typically, the PRC courts does not enforce an interim relief by a foreign court or a foreign tribunal, and it also does not itself grant interim measures in aid of an arbitration held outside mainland China. That has all changed with the recent interim measures arrangement between Hong Kong and the PRC courts, which came into effect in 2019. And so if that dispute that I had just mentioned occurred now rather than a few years back, it is certainly much more timely and effective to go to the PRC courts directly to get a preservation order. In essence, a party to a Hong Kong-seated arbitration administered by one of the 6 qualified institutions based in Hong Kong, including the HKIC and the ICC, may take advantage of the arrangement to seek asset preservation, evidence preservation, and conduct preservation from the mainland courts. The applications are made through the institution, which then passes on to the PRC courts to decide upon. And this can also be made even before the commencement of an arbitration in cases of urgency. And generally speaking, the standard for ordering an interim measure are more generous than obtaining interim relief from a Hong Kong court or a common law court. Now, at the conclusion of the arbitration, in other words, once the final award is made, a Hong Kong award can be easily enforced in mainland China under the mutual arrangement for enforcement, which has been in effect since the year 2000. Now, the permitted grounds for refusing enforcement are very limited and mirror the same narrow due process grounds permitted under the New York Convention. And importantly, if the local court refuses to enforce the award, that decision must be approved by the Supreme People's Court in Beijing before it can take effect. And so this mechanism of reporting up ensures that no award will be refused enforcement by reason of local protectionism. The enforcement regime is recently enhanced by the supplemental arrangement which came into effect in November last year. And effectively, this allows the PRC courts to make an orders of asset preservation when the enforcement application is pending. And so again, this is another very powerful tool for foreign parties when it comes to enforcing their awards against the PRC parties. So far, so good about the support from the PRC courts. What about the Hong Kong courts? Now, one of the consequences of selecting Hong Kong as the seat of arbitration is that the Hong Kong courts will have a supervisory jurisdiction over the conduct of the arbitration. And the question then arises as to what is the Hong Kong court's attitude towards arbitration? After all, award is not of much use if it can be easily set aside or if you have a very interventionist judiciary. And to that end, the court has been very clear about its role. The case on point is China Solar Power. And in that case, CSP, the PRC company, had sought to set aside the award against an award made in favor of the foreign party on the grounds that CSP was unable to present its case. The Hong Kong courts dismissed the application and made it very clear that the Hong Kong court's role is to facilitate the arbitral process and to assist with enforcement. So it is concerned only with the structural integrity of the arbitration, and furthermore, any conduct complained of must be egregious before it will agree to intervene. And importantly, the court does not review the merits of the arbitrator's decision. Also, I should note that to disincentivize any unmeritorious challenges, the Hong Kong courts award indemnity or full costs against parties who unsuccessfully tries to challenge an award or an enforcement order. So all in all, I think given the procedural as well as the institutional safeguards and arrangements supporting enforcement and interim measures, I think ASEAN parties can be confident in practice that Hong Kong remains, if not a viable, a preferred venue to arbitrate their China-related disputes. Thank you.
Thank you, Freefen. And now on to our final speaker. Before we begin the panel discussion, Kiran Sangria, who is going to share with us why Hong Kong has long been the preferred dispute resolution center for ASEAN companies, while outlining a few of its unique advantages. Kiran, over to you, please.
Great. Thank you so much, Lewis. And also, I suppose it's in some ways intimidating to be following Maria and Friven as two very distinguished and experienced practitioners in the region, and both from ASEAN, or very strongly connected to ASEAN, as well as the work that's happening in Hong Kong and in the GBA. But I shall do my best. So, as Lewis said, I'm special counsel at HKIC, and I have been with the institution for almost a decade, and I've been actively involved in handling arbitration cases over the years. What I want to bring to this discussion or these presentations is the institutional perspective, which is very important, as institutions play really a fundamental role in what makes a good arbitration hub. And in this instance, what would be of most interest to users who are looking not looking for disputes, but who end up in disputes related to the GBA from an ASEAN background. So what I will cover, and I shall try and do so briefly, is essentially what ASEAN users should be looking for in their arbitration hub for GBA disputes. What does this essentially mean? GBA disputes, effectively cross-border disputes involving Chinese elements. And in the context of today's presentation, that would be disputes arising between ASEAN and GBA parties, i.e. Hong Kong, Macau, and southern China. I'll cover off 4 topics and approach some of the final topics with a slightly different angle to those presented by Friven to hopefully supplement the institutional perspective there. But essentially what you should be looking for are 4 things. An experienced and neutral institution that is able to handle cross-border, in this instance, ASEAN and China-related matters. Cost and time-saving measures that the institution can offer. This is really essential, a conversation that we're having regularly in our international arbitration community. And then tools to maximize recovery. Friven spoke about this. There is no point in having a paper judgment, one that really at the end of the day, there's nothing there for you to ultimately recover. So that's crucial in the arbitration hub that you're looking to select. What does that arbitration hub offer? And then finally, the seat. So where HKI sits is Hong Kong. So we can handle and frequently do handle disputes with the legal place being in Hong Kong. And that's what I'll focus on today too, and why that's important. So an experienced and neutral institution, why is that important? Well, essentially an institution plays a fundamental role in managing arbitration proceedings. The role of an institution can really enhance the enforceability of an arbitral award by ensuring that the procedure is run efficiently and fairly, and where it's necessary, and arbitrators are required to be appointed by the institution, that the institution has the pool of arbitrators needed to serve independently and to accommodate the specific cultural and legal jurisdictions that are relevant to that particular dispute. So paying attention to the institution is pretty crucial, in short. So does HKC do that? And I think you know the answer will be yes. A few points here by way of introduction. So HKC certainly is experienced. We've been around for a long time. At 1985, we were established, and we've handled well over 10,500, almost 11,000 cases to date. So a safe pair of hands. Importantly, we're independent. So the decision-making of the centre, there is no intervention by anyone other than the standing committees and the case management team at HKIC. There's no government involvement in the case management at the centre. International recognition certainly helps if it makes you feel better. I think it's good to know that HKIC is one of the top 4 arbitral institutions globally. So that's, taking into account some of the major arbitral centres in the world. And I'll talk about arbitration today, but it's also important, as Maria mentioned, to look at other ways to resolve your dispute, including mediation being an important one. And HKIC also offers mediation, adjudication, domain name dispute resolution in addition to arbitration. So don't forget the institution when you're thinking about your arbitration clause. Touched on this a little bit, but it's important, I think, for users to know who are the people who will be making decisions and managing your case. You can see some faces here, and one might be familiar. In the Proceedings Committee, Friven Yeo, who sat next to me, is a valued member of that committee, which is responsible for procedural decision-making on our cases. For example, whether HKIC can accept a case, or alternatively, whether an expedited procedure should apply. We also have the Appointments Committee, again, a very important committee where HKIC is required to make an appointment. That appointment of an arbitrator will be made by this committee. We don't always need to do that, as Friven mentioned, but when we do, this is the body responsible. And then there's the Secretariat, who do the day-to-day case handling. So why am I mentioning this in the context of ASEAN and GBA? Well, I just want to highlight that our decision-making bodies and our Secretariat include practitioners that are based in ASEAN or from ASEAN countries, including Singapore, Malaysia, and the Philippines. And as Friven said, it's important to have those individuals that will understand the legal culture and the different issues that parties from these regions face, and take all of that into consideration when making decisions in relation to a specific case. Experienced and international, so as you would want in the institution you select, that they be able to handle cross-border disputes. It really is a prerequisite in the context of today's conversation. Looking at the map there, it's really global in terms of the parties involved in HKIC's cases in 2020. The larger the dot, the more number of users we have from those places. But you can clearly see there on the right-hand side, we do have a number of cases involving ASEAN parties, 57 in fact in 2020. They included Singapore, Malaysia, Vietnam, Thailand, the Philippines, and Cambodia. As you may expect, the top 10 users year in, year out in HKIC's caseload are from Hong Kong and do frequently include mainland China as the second in terms of geographic origin. So this chart really goes to show that we do have significant experience in handling frequently disputes involving mainland Chinese and non-mainland Chinese parties, and in particular disputes involving mainland Chinese and ASEAN parties, really the topic of today's webinar. This is my second point about what you should be looking for. Tools for saving time and cost. This is not always a given, and therefore you should be making inquiries of the institution as to what they offer in this regard. So once you've established your institution is neutral and also experienced, you should be looking for various measures, including those that relate to cost. For example, capping arbitrators' fees, time-saving measures. I mentioned an expedited procedure, which means that the arbitration can be concluded within 6 months from the appointment of the arbitrators. Efficiency in complex arbitrations. So the example that Friven mentioned, or that Maria was talking about in terms of the types of deals that are happening, it's much easier if a dispute arises across a number of contracts in a complex arrangement if you can combine those disputes to make sure that you're not duplicating costs in terms of running those 2 or 3 or 4 procedures separately. And technology, huge cost-saving measure where appropriate. So last year, we offered a number of virtual hearing services to parties across the globe, including from China and including from ASEAN. It may not always be appropriate, but I think it's helpful for ASEAN users to know that virtual hearings are an option in the appropriate circumstances. Maximizing recovery, and I'll just touch on this briefly as Friven mentioned the arrangements in detail. What I will say is there are essentially two very valuable arrangements, particularly in relation to recovering in mainland China. The arrangement on court-ordered interim measures. This is useful prior to the arbitration and during the arbitration to preserve assets, evidence and conduct, as was mentioned. And then the second arrangement, just on this graph here, is really in relation to once the arbitration is concluded, how best to recover if an award is found in your favor and assets are in the PRC. The first one, this is the arrangement on interim measures. As mentioned, this is really a game changer for Hong Kong, and HKIC is one of the institutions who is able to benefit under the arrangement. I'll talk a little bit here about HKIC's practice, highlighting what we do, really two simple points. Our main role is to issue a letter confirming that the arbitration has in fact been filed with HKIC. We usually do that very quickly, within 24 hours. These applications are often urgent, as Friven said, to ensure then that the courts in the PRC have the requisite confirmation that they need. Now, is this really a useful arrangement in practice? I think absolutely, and I say that based on HKIC's experience since October 2019 when the arrangement came into force. There's a real commercial benefit, and we've seen both PRC parties and non-PRC parties, including parties in ASEAN, for example Singapore, benefit from the arrangement. So a Hong Kong seated arbitration administered by HKIC, what have we seen? 38 applications have been made to PRC courts in arbitrations handled by HKIC. Not small figures. Those applications are worth almost $2 billion US. And the courts in the mainland are also applying the arrangement. The courts have ordered orders in the value of $1.6 billion US worth of assets. So that's significant. In terms of the applicants, as I mentioned, it's both mainland Chinese and non-mainland Chinese parties that are benefiting and making applications, and they're in relation to assets that are owned by mainland companies, but also foreign companies. So I think if there is any Chinese element, whether that's assets or parties involved in a potential deal, then it's worth really thinking about Hong Kong and HKIC for that added advantage. Enforcement of awards was mentioned by Friven. I will just say here, again, this is working in practice since 1999 or the year 2000 when the arrangement came into force. Only 3 HKIC awards have not been enforced in mainland China as far as we are aware. So that's a really compelling number given the number of arbitration cases we've handled involving PRC parties where arbitral awards would have been enforced or attempted to be enforced in mainland China. Concluding shortly here, but I just want to mention that the fourth point really, the seat, neutral and pro-arbitration. Friven talked about enforcement of awards in Hong Kong. I'll just mention that the arbitration framework here will be familiar to many. It's based on the UNCITRAL model law. So whether you're from an ASEAN country, from China, this is a piece of legislation that you will have seen, and it's one of the most up-to-date pieces of arbitration legislation in the region. It's regularly updated to make sure we capture recent developments. So for example, IP disputes it's been clarified, are arbitrable in Hong Kong. We have an international and specialist judiciary. So in terms of our Court of Final Appeal, we have foreign judges that sit, non-permanent judges who come from over 14 different Commonwealth countries. And they really are really a testament to the quality and the independence of the Court of Final Appeal. Also importantly, there's a specialist arbitration judge who knows exactly the scope of judicial intervention when it comes to arbitration matters. There are a few points here that I think are just worth soaking up based on what I've said and what others have said today. Hong Kong and HKIC really are the go-to options for ASEAN and PRC parties when it comes to their contracts, and if disputes arise, the benefits that a Hong Kong and HKIC combination for arbitration does offer. Experience for exactly those types of disputes, cost effectiveness and efficiency for complex proceedings, experience in the types of disputes involving the types of jurisdictions and parties from the region and that might arise in the GBA context. We make it very easy, and this is my last slide. We make it very easy for you to choose your appropriate arbitration hub for Chinese, non-Chinese contracts. There's a model clause, and Maria alluded to this in one of her final slides. It's best to follow that. You don't have to, and there are options in there, but if time is short and you want to include a safe option, then I would always suggest going to the model clause. But those are my brief thoughts on what users should be looking for in their institution for a China, non-China dispute. Thank you.
So thank you, Kieran. So let's move swiftly on to the panel discussion, where we will be focusing on the particular practicalities of resolving GBA-related disputes. But before we do, just a reminder, please type any questions into the question box on your control panel, as we will shortly be moving on to the Q&A section. So please allow me to follow the sequence of presentation and ask the first question, or throw the first question to Maria. So we would like to hear from you, from your experience. What are the key areas of growth of the use of arbitration, you see in ASEAN?
Thank you for that. The areas of growth, I think, will track the areas of growth and investment that we've seen in the BRI trending. And none of this will be surprising to those of us who've lived through the past year. And there are certain trends that are, I think, very, very clear. One is energy and infrastructure, and particularly renewable energy and sustainability investments. That's only going to grow. We've seen a number of corporates shift their policies, and ASEAN is ripe for those kinds of investments. The second is the area of digitalization. Again, in the context of e-commerce and fintech and artificial intelligence. And the third is logistics, as we've talked about before. And we'll just note that logistics was the largest growth area of BRI in 2020. An example of that is when Blackstone invested $1.1 billion in the GBA's largest urban industrial park. So this is the kind of trending in terms of investments. This is not to say that the traditional Belt and Road projects, they're actually probably in more mature phases or have been stalled by the pandemic. And so there will still necessarily be disputes related that may arise in connection with the different cycles of those projects.
Mm-hmm. So given all those trends you just mentioned, what will be your advice for GBA businesses? Any tips for them? Major factors to consider before embarking their ASEAN journey.
We've touched on a number of those. Without getting into too much granularity, I'll just say do the upfront work first. Mm-hmm. Each jurisdiction is different, mm-hmm. and each jurisdiction will have distinct regulatory and policy hurdles or challenges or opportunities for your specific project. So localize, do the homework, and make sure that your structuring is correctly thought out before you embark.
Okay, thank you very much, Maria. We will come back to you later. So let me turn to Freeven. So how popular is actually Hong Kong law a choice of governing law for ASEAN companies in their commercial contracts?
I'd say that it is a very popular option. And I think that's got to do in large part because Hong Kong has a strong common law tradition that many international parties are familiar with, and together with, of course, the rule of law as a cornerstone of Hong Kong society. And Hong Kong law development tracks very closely those of the other common law jurisdictions. So you are getting a very up-to-date, users-friendly and certainly responsive and modern piece of a governing law if you choose Hong Kong law. And I think another point to make is that the central government has indicated its commitment to one country, two systems, which means that Hong Kong law as we currently understand it will continue in the foreseeable future. But that said, I think it's also important to note that Hong Kong's viability as an arbitral seat and whether the party should choose Hong Kong law to govern their contracts are two kind of separate questions. I mean, they go in tandem in the sense that the parties have to opt for a governing law and also an arbitration clause. But parties do not have to choose Hong Kong law to take advantage of Hong Kong arbitration or vice versa. It is possible and indeed very common for parties to select other governing laws in their contract and at the same time provide for arbitration in Hong Kong. For example, apart from Hong Kong law, as I understand it, some of the other very popular governing laws that we handle in Hong Kong arbitrations would include English law, New York law, and PRC law. So hopefully that answers your question.
And other very intriguing question to follow is how does Hong Kong compare with Singapore, for instance, as a place for arbitration, especially when it comes to GBA? So if I'm a company, I have more or less the same amounts of business in ASEAN and in Hong Kong. So how should I choose?
Yes, and certainly a very a hot topic, you know, the Singapore and Hong Kong rivalry. I'd say that generally speaking, both Singapore and Hong Kong are viable venues for arbitration. Both adopt arbitration-friendly laws that are based on the UNCITRAL trial model law that Kieran has mentioned. Both are very established disputes hub. But I'd say that the growth of one market is not at the exclusion of the other. Yeah. Both have experienced exponential growth over the years in terms of the number of disputes, the value of disputes that they handle. So I think it is a growing pie for both Singapore and Hong Kong. Each will have its competitive edge and will do well to attract different markets. But I'd say that in terms of GBA and China-related disputes, Hong Kong is still unrivaled for the reasons that I've mentioned on interim measures, arrangement, the language issues, geographical proximity, etc. The respective flagship institutions, HKIC and SEAC, are both well respected. Now, each offer a slightly different product in the sense that HKIC is what it considers to be more light touch, while the SIAC has a more formal scrutiny process over awards. But that's not to say that you know, the quality of one is better than the other. The HKIC also conducts an informal scrutiny of the arbitral process. But at the end of the day, HKIC awards have an excellent enforcement record in the PRC, as Kieran has mentioned. So the quality of the award is only as good as the arbitrators you appoint, I'd say.
Yeah. So from the practical point of view, it's always good to have a variety of choices. So Kieran, so what types of dispute HKIAC sees involving ASEAN and Chinese parties most? Okay, do they mirror what Maria just mentioned for the ASEAN market?
Yeah, yep, good question. I think the short answer is we see a variety. That might be obvious, but we certainly do. I mean, we've seen disputes that are maritime, so charter party related. We've seen quite commonly, I would say, sale of goods, goods being a very broad definition. So, you know, that could be iron ore or textiles or IT equipment, but the commercial space where people are selling and buying, that's happening, and we're seeing disputes arise there, for example, for failure to pay or for the quality of the goods not being up to scratch. And I would just highlight here that there's no trend really whether the PRC party is always the claimant or the ASEAN party is always the respondent. It's certainly, or vice versa, that's certainly not the case. You know, there's really a split, and you can't really see a clear trend as to who the respondents and who the claimants are. And we're also seeing, and Maria spoke about this at the outset, the sort of big infrastructure disputes. We have had a couple of disputes involving Southeast Asian countries and the investment and infrastructure investment coming from big PRC state-owned entities. So the types of projects along the Belt and Road. So it's really a broad spread.
Another very interesting thing that I saw many people have that in their mind is that if we are processing some mainland-related disputes here in Hong Kong, does Hong Kong remains a neutral and effective seat for arbitration of that? Okay, because would it be biased or to a certain extent at a disadvantage of the ASEAN-based or foreign-based businesses?
Yeah. So that's an important question, and it's one that we do receive from time to time, and I'm sure practitioners in Hong Kong do. Certainly questions from those who might be less familiar with the system and how it operates here. But we've spoken about one country, two systems, and we've spoken about Hong Kong specifically, and I think that highlights and it's a fact that Hong Kong operates under a completely separate legal system, hence why we need arrangements between Hong Kong and mainland China with respect to enforcing awards. A Hong Kong award is classed as a foreign award, and why we need special arrangements for seeking interim measures from mainland China. Again, because we're not part of the same legal system, the courts are separate, and for commercial decision making, there are, in arbitration, nothing has changed over the past decades. So what's important for arbitrations and neutral decision making? Well, Friven touched on the appointment of arbitrators, and he's explained why that's a neutral process, and actually parties have a say in that. We've spoken about the laws that operate here. They're separate from the mainland, and they are modeled on United Nations promulgated arbitration law, so internationally familiar and accepted. The courts here, specialist judges, there are decisions that are made here in Hong Kong and have been for a long time in favor of supporting the enforcement of arbitral awards against Hong Kong companies, against mainland companies, against SOEs in mainland, against foreign entities elsewhere across the globe. So it really is a very robust and independent system for commercial decision making, whether it's a mainland party or a Hong Kong party or wherever the party might be coming from. I think people just need to remember we've been doing this, and not me personally, I'm not quite that old, but doing this for a long time, and the courts are very established, and the arbitration infrastructure here is separate, and there are many safeguards in place to ensure that.
Okay, with that, in the interest of time, I think we can only have time for one question. First, I think this question is for all of our speakers today. The question reads like this: Is there virtual arbitration, and are there any implications for remote hearing, considering the travel restrictions imposed due to COVID, and from time to time disputing parties in BNR or Greater Bay Area projects may come from different jurisdictions and countries? Are online arbitrations really fair and legal binding to enough, okay, to protect everyone's interests? So may I ask Friven to kickstart?
Yes, certainly. I think this is a very relevant question with the COVID pandemic. And in fact, just speaking from experience, I think over the last year, I think parties have really adapted well towards the shift from in-person hearing to virtual hearing. Of course, part of it is a practical consideration. I mean, we don't know how long the pandemic's going to last. And do we then wait till everything is over before the parties try and resolve their disputes finally? And I think I think parties have been practical and pragmatic in deciding that, look, we need to explore a different way of doing things. And what we have seen over the last year is parties very quickly adapting towards the use of virtual hearings. So the HKIC, I've done virtual hearings at the center. Everything is well set up to allow for that to happen effectively, I should say. And with the use of technology, modern technology, the disadvantages, the perceived disadvantages of not being in person, I think that's dramatically reduced. And you can certainly see your opposing party, your witness, very clearly, and I've not had an issue cross-examining a witness on a screen, which I think some of us, not having had tried that before, might have some apprehension. But having gone through that, I think because of the modern technology, everything is so clear. I think even if somebody tries and do funny things, I think it's very evident. And of course, there are also procedural safeguards that the parties will try and set up in terms of the rules of engagement as to what is permitted, what is not permitted, having a neutral person in the room, holding the cross-examination or the proceedings at a neutral venue, etc. There are well-established protocols to support the use of virtual hearings.
I would just add to that, Louis, just a bit of colour from HKC's experience. So last year, 80 of the hearings held at HKC were virtual. So people are adopting that approach because they have to, but also I think they've realised that if you prepare well, you have the right equipment and stable internet, which may not be the case in every jurisdiction, but if you have those things, then you can effectively run a hearing. I would just say that people do need to look out for the question on enforceability is just to make sure that in terms of any applicable rules or local laws for enforcement, wherever you might be taking an award, that virtual hearings are permitted. I mean, that's an important point to look out for. But if that's all fine, then on the practicalities of it, people are doing it and it's working well.
So Maria, we're here to wait. We're waiting for your concluding remarks on that.
I definitely defer to my arbitration practitioner colleagues on this point, but it has also been our client experience that virtual hearings have worked very, very well. And as Friven noted very early on, they do tend to help level the playing field in terms of participation, which I think is just a good thing.
Yes. So I think the pandemic has changed many business, including that for arbitration and the practice of arbitration. So I must say it's a pity that we have more questions than the time we have for. So it's just left to me to thank our eminent panel members for their time today and to thank all of you who have joined us remotely for this section. I look forward to welcoming you all back very soon. Thank you and goodbye.
Thank you. Thank you so much.
Thank you.
Thanks.